So we're going to get into everybody's favorite statute right now, Bill 142, Construction Lien Amendment Act 2017. This is now coming very close to reality for our lives in the construction industry. And it's suddenly everybody's perking up and paying a lot more attention than they have for the last couple of months as we gear up. For those who are not aware, just a bit of brief background on this. The Act received royal assent and became law on December 12, but it's being phased in 2 stages, essentially. There is a bundle of changes that are coming that we loosely refer to as the modernization changes. These are coming into force July 1, so this is very close now. These are changes, updates, modernization pieces, amendments that have been needed, tweaks to the statute, which hasn't really been significantly updated or amended since it was enacted in 1983. So there's been a few changes in the construction world since then, and these are catching up to a lot of that. And then the second piece is the real culture shift that we're going to have next year, and this is prompt payment and adjudication, a fast-track dispute resolution tool for resolving payment disputes. Those pieces are coming in next year, October 1, 2019, and we'll talk a little bit about the transition rules because they're a bit tricky to understand and important to understand. But those are the 2 pieces coming in, and we're going to start talking about those in a minute. Part of the modernization pieces in the prompt payment and adjudication, obviously bringing in a lot of things that are not lien related. In fact, the Act is now going to be called the Construction Act to reflect the fact that while it's always dealt with things that are not just liens, it's really going to be a construction act. It's dealing with a lot more things than just lien rights and lien procedures, and they've changed the name to reflect that. The grandfathering rules were introduced when the bill reached its final reading in the legislature. So fortunately, initially there was not going to be any grandfathering, so if you had heard that you had to get going and adapt for existing projects, they changed that rule with an amendment to Bill 142 in December. And so any existing project, and that's pretty broadly defined, is going to be grandfathered and will continue to be governed by the current rules. So by existing project, they define that very broadly, fortunately. So anything that has a shovel in the ground, a contract signed, an RFP or a tender already issued, or even any kind of procurement process that's already been initiated, you will remain in the existing regime. And if those were launched, if the procurement process was launched before July 1. So, there's a question of what does procurement process mean? There's a little bit of guidance in the statute, but essentially, if you've got the general sense is if you have a procurement process, a qualification, let's say, request for qualification out there in the market, and it's specific to a specific project, that project will be grandfathered and continue under the current rules. If it's just a general request for qualifications to put contractors or other parties on a panel or approved contractors list, but without a specific project in mind, it's probably not going to be sufficient to grandfather that project into the existing rules. So we do have to pay attention. Master Sandler recently issued an affidavit, a notice to the sector, and at the OBA we sent out a notice to all members announcing that the Masters courts will expect affidavit evidence from parties showing that which regime they're in, so that we can proceed more clearly. I'll get your question in 1 second, and just also 1-year grandfather, when your project is grandfather or not, that applies to the whole regime, the whole construction pyramid. So you're not going to have split regimes in the construction pyramid between contractors and subcontractors and subcontractors. Question at the back?
You talked about grandfathering. When did the grandfather date, if I put something out for an RFP, for argument's sake, July 2nd, would that be the grandfather date, or?
July 1. So anything issued July 1 or after, the new modernization piece of the rules will apply. There's the second round of transition period will be in October 1, 2019 for prompt payment and adjudication.
Thank you.
Okay, so there is a lot going on with the statutes. Gowling's has been very involved in this from the beginning. We've published a lot of articles and we've had other many events. This particular event is being recorded so that we can put it onto our website. We've actually collected all of the materials that we've done and all of the events that we've already hosted and that we are planning to host onto a Construction Lien Act website that we've created, our hub for Construction Lien Act reforms, which you can go visit and encourage your other colleagues to go to collect additional information if they aren't able to attend our events. So getting on to the modernization piece, generally I look at these changes and I kind of put them into three buckets. There's a whole bunch of changes which are just kind of learn it, know it, and remember it next time you get into the project. Not a lot of complexity to it, a little change in the definition or what have you, and move on. Then there's a bunch of changes that will require some step back and thinking, okay, do we need to change our documents to reflect this? Is there some tweak that we need to do in our procedures or our certificates or anything like that? And then there's a few changes that are really quite monumental and require organizations to really step back and think, do we actually need to buy some document management systems, or do we have to do some more training, or do we have to actually go out and hire somebody to manage this new process, because they're quite more significant and involved. And so a lot of the changes, and there are a lot of changes that are coming, fall into the first bucket, fortunately, but they're important to know. And I think a lot of the focus in a lot of the programs that I've been to or articles that I've read focus on the prompt payment and adjudication piece, because they are big and they do involve a lot of changes in the industry and at different organizations. We flipped it around, and we're going to focus today on starting off on the modernization pieces and reforms, because those are coming soon. And there's a lot of them, and we're going to cover some of the more, I think, more important ones. But it does merit some good sitting down and reading through of articles or whatnot to cover all of them, because we just don't have the time to cover all of them. The Bill 142 came out of a report, an expert review report that was provided to the province that made 101 recommendations. And actually, in fact, within that, there was even more recommendations. So we have a lot of changes to grapple with, and I think we just need to get right into them and start off. So, as many will have heard, the lien periods have extended. As Natasha mentioned, we now have a 45-day lien period from substantial performance, last day of supply, or abandonment. We now will have a 60-day lien period from substantial performance, last day of supply, or abandonment, and we're also adding a fourth criteria from termination. So that 45-day period of preservation of your lien rights is now extended by 15 days to 60 days. Part of the idea here is to give parties more time to work out disputes, settle change orders that are not agreed, and avoid bigger disputes and lien claims during that period. And it was thought that 60 days would be more adequate time. You're talking about 2 payment cycles roughly there, and so that's more time to work out disputes. Similarly, the perfection period, which is the period, so the preservation period is when you have to file a lien claim or on title. You're go in and register that against title to the property. The next step to keep your lien rights is to actually issue a written notice of lien to the owner. And this period, which is currently 45 days from the end of the first 45-day period, is now extended to 90 days after the end of the lien period. So that's a total of 150 days before claims really have to get going and lien claims are fought out. So that, again, that is giving parties a lot more time to work out disputes and changes in the effort to avoid going to court. So if you have procedures and documents that refer to 45-day window of payment of holdback or If you've got systems where you're checking title on the 45th day, you're going to want to change those to update to the current, the new time periods. And do you have extra cash flow in your organization for those extra 15 days? Because we're now 2 payment cycles out. And do your contracts need to be updated to reflect the new regime? I get asked often, do the standard form CCDC contracts need to be updated for all the Bill 142? And in some ways, they don't, because the CCDC documents, if you use them, you know they're national documents. These laws are all just Ontario, and so they're designed to be a little bit generic. They speak to the end of the lien period as opposed to a specific 45-day period. But if you do have supplementary conditions, as many people do, or you have your own standard form documents and they refer to a 45-day period, you're going to want to go back and update those for sure. And a lot of people have their own systems internally for tracking lien time periods. You're obviously going to want to update those to 60 days as well. There are a number of changes to the holdback regime, not just the pushing back to the 61st day. Right now, the Lien Act actually does not stipulate that you must pay the holdback. It simply says that the owner is not allowed to pay the holdback until the end of the lien period, which is 45 days now. We will now have a rule that the owner must pay on the 61st day the holdback. So this is now a mandatory obligation that cannot be avoided in contract, and the owners will have to comply and pay on that 61st day at the end of the lien period. So that's a big change for a lot of people. The current regime allows you to set off against any holdback. You're always been allowed to set off for deficiencies or other claims that an owner might have against a contractor. That doesn't change, but what does change with that is now you're going to have to actually give a formal notice. It's in a prescribed form. If you as an owner are intending not to pay the full amount of the holdback to your contractor, you're going to have to issue a notice, publish the notice, and it has to be published 45 days after substantial performance. So this is actually a bigger change, frankly, than the mandatory payment, I think, because owners, if they miss this date, they have to pay the full amount, even if they have deficiency and offset claims. So owners have to pay attention. They have to get their mind around what amounts of the holdback are in dispute, issue the notice, and of course the notice is published so all the subcontractors on the project are going to be aware of it as well. And the idea here is we're going to put all our cards on the table. We're not going to have any last-minute surprises. With the extended lien periods and the requirement for a published notice of non-payment, we're trying to avoid that perennial standoff at the end of the project where contractors want payment or else they'll lien and owners say they won't pay if there is any lien. So we're tilting it a little bit in favor of the contractor here because they're going to know how much money they're going to get and whether there is something in dispute. We also have an extra 20 days as a result. Once we know what the situation is in terms of how much holdback is going to be released, we know where the money is, what money's coming, and we've got that 20 days to settle the disputes with knowledge. Obviously, we'll have to check our contracts and make sure that to the extent that they have anything other than a payment at the day after the expiration of the lien period, those contracts will have to be updated. And the publication has to go into a daily construction newspaper. Right now, that's only the Daily Commercial News. Some other changes on holdback. Right now, the Act only allows an early release of holdback if a subcontract is fully completed and the owner and contractor agree or the architect certifies that the subcontract is fully completed. Part of the whole exercise here with these amendments is to get cash flowing in a project quicker. So one of the things they've done is they've said, well, look, we have large projects that go on for years, and we have large projects that have multiple phases that really are almost full projects unto themselves. So we're going to allow parties to release holdback early on an annual basis and on a phased basis. So if the project is a large project over $10 million and there's no liens registered on title, and your contract explicitly allows for the early release of holdback, then you will be allowed to release holdback on an annual basis, on a calendar year, or on a phased basis. In other words, if you've got milestones, we're going to release holdback, and it explicitly says in your contract, we're going to release holdback at the completion of the pouring of the concrete. We're going to release holdback at the completion of the podium of the tower. And we're going to release holdback when you complete floors 1 through 6 of the condo above it. And then holdback on floors 7 through 10. You'll be allowed to, and release holdback early for those contractors and subcontractors who are on the project from the more or less the beginning all the way through to the end. So this is going to free up a lot of cash on the holdback for the benefit of subcontractors and suppliers in particular. But it must be explicitly in your contract, and there can't be liens when you release that. Another change they're adding, right now the current act looks at a project and kind of defines a project by virtue of a contract, through the prism of a contract. If there's one contract between an owner and a contractor, then we're going to treat that as one project. Any work under that one contract is deemed one project, which means there's one date of substantial performance, one date for the expiration of the lien period, and one date for holdback release. But the reality is, more and more, we have bundled projects, especially on big infrastructure projects, where we'll hire somebody, the owner will hire somebody to do multiple improvements on different lands. And really, they're standalone projects in a lot of ways, two or three schools. Or developer hires somebody to come in and install brand new HVACs in all of their different buildings. If it's one contract, you have to treat that as one project. There will be a new rule that will allow you to treat each of those projects as separate contracts for the purposes of the Act, which means you've got a separate substantial performance date, separate lien period, and a separate holdback release date for each of those separate projects, as long as they are fully separated lands, non-contiguous lands is the language that's used, and you've spelt it out in your contract that you're going to do that. So again, we'll be able to release some funds earlier and get cash flowing on the project sooner with these rule changes. What's not clear, though, to me, is what happens when those terms in the contract aren't passed down fully to the subcontractors and suppliers. So I like to flag this because it's not clear to me how this is going to work out in reality on projects. The statute says that the owner and the contractor can do this, but what if the contractor doesn't pass down that express permission or definition of different projects in their subcontracts, and you've got one supplier or one electrical contractor who's doing all the work on all these different projects? And how does that play out in reality when that subcontractor doesn't get paid? Do they have a claim against all the properties, or just the one for which the work was being performed? That's not perfectly clear to me at this point, so it's something to pay attention to. Some new trust accounting rules, and this is actually a subtle change that I think goes under the radar for a lot of people, but it actually could have a very big impact for a lot of different organizations. Right now, the Act specifies that anybody who receives any money on a project that's payable to somebody else on the project, there's an automatic and statutory trust that applies to those funds. By virtue, and there's not much else in the Act than that. It's essentially relying on hundreds of years of case law that says once there's a trust, you've got all sorts of common law obligations, fiduciary obligations with those trust funds. You can't use the funds, for example, other than for the purposes they're intended. You can't take those trust funds and go pay off your mortgage or go pay off your debts on another project. You have to use them for the project. So that rule has always been there, and that doesn't change. What does change now is that contractors and subcontractors will now be obliged to put those trust funds into a trust account. So no longer will you be able to hold those in your general operating accounts. And secondly, once it's into the trust account, you have to apply trust accounting rules and bookkeeping procedures. So you have to treat all the funds. You are allowed to have one trust account as an organization for all of your projects. You don't need to have a separate trust account for every project, but every dollar that's in that trust account you need to keep separate books for. The idea here is to keep your funds traceable. This is a result of 10 years or so of a bankruptcy case law where a trustee in bankruptcy has come along and said, I see a lot of money in this general operating account. I can't tell what's a trust fund and what's just general revenue because it's all commingled. And so I'm going to take it all. And notwithstanding that some of it's holdback or other monies that are owing to a subcontractor, because the funds are commingled, and because federal bankruptcy laws have paramountcy over provincial construction laws and priority rules in the Construction Lien Act, the trustee's been able to do that and the courts have enforced that. So the attempt here is to segregate out as much as reasonably possible the funds so that they're a lot more traceable. So there's a lot of concerns that arise from that. Certainly with smaller contractors, are they ready and aware of this need? Have they set up the trust accounts? There is a lot of concern in the lending world about just how strong the receivables are and are they taking the right reserves for this. There's a concern that really borrowing bases have been calculated based on receivables that included trust funds perhaps. And now that's going to be a lot harder to do, and so what is the real financial strength of their borrowers? There's certainly a lot of concern that contractors, especially smaller contractors, are just going to ignore the rule. Remember, every payment to a contractor is included both fees and profits that they get to keep, as well as trust funds. So how much of the fees are in these amounts, and what are they doing with them? That's going to be it's going to play out for a little while. I think we're going to see a few cases, and then people will start to wake up to the reality, and we'll start to evolve best practices, I would expect, that dictate owners will want to pay directly into trust accounts rather than to operating accounts, or other procedures that protect them from claims from subcontractors who won't get paid. There are, I've just put this up just to show you the rules are in 8.1 sub 1 for the trust accounting rules. We don't need to go through that here, but this is an important one to note. Are you ready for accounting on these trust funds? Are you ready with your trust account ready for the new projects coming after July 1? Anybody work in the P3 world here? A few hands. So right now, because of this rule I mentioned before, one contract, one project, that also means one owner. And so typically, we kind of don't realize in the P3 world that Project Co. is actually a contractor under the Act, and the design build contractor is actually technically a subcontractor, because the Project Co. doesn't have an interest in the lands, and so by virtue of the definitions of the Act, they're actually a contractor and not the owner, even though they really are the owner of the project. So a small change, but a fairly significant one for P3 projects, is that the Act will now deem Project Co. a special purpose vehicle established for the purposes of that project to be an owner for the purposes of the Act, even though they don't have an interest in the premises of the project. So that will clean things up a bit in how P3 projects work with the Act, and have a better tie-in between the Act and how the completion and progress of the construction. To the extent that anybody actually tried to fix this in their own contracts, you'll have to catch up on those as well. Make changes to your documents and forms.